All right, good morning. My name is Mr. Shepard. I'm the principal of Paragould High School. We want to welcome you to Paragould High School today for this great event. Thank you for coming to Paragould School District. We want to say thank you to our friends from Greene County Tech and Conway Academy, as well as our students here from Paragould High School. There we go. Excuse me. So we want to welcome our guests here from Greene County Tech and Crowley's Ridge Academy and our Paragould High School students, as well as we have many state officials and city and county officials. We thank you guys for coming as well. So on behalf of our superintendent, Dr. Jankowiak, and our school board here at Paragould School District, we want to say welcome and we thank you guys for coming to this great day. We hope that having students here witness these court proceedings is a truly educational experience. This type of education is a key component in the preservation of our great nation and the rule of law. I will now present some rules of decorum and a brief description of the case that we are about to see. What you are about to see is an actual proceeding of the Arkansas Supreme Court. The justices will ask the attorneys questions about the case before the court. This is called oral argument. All rules and decorum normally observed in the Supreme Court's courtroom in Little Rock will be observed here today. In a few moments, the bailiff of the court will announce, "All rise." This is how the court is opened. You will be expected to stand, if able. As soon as the bailiff says you may be seated, you should take your seat and not get up again until the bailiff instructs you to do so. While court is in session, there will be no use of electronic devices of any kind. If a cell phone or other device goes off during the proceeding, it may be confiscated by the bailiff or other law enforcement. Please remain silent during the proceedings. Any person talking or creating a disturbance may be removed. Please respect the dignity and seriousness of the proceedings you are about to see. Now here's the statement of the case. CR-21-195, Robert Smith versus the State of Arkansas from Faulkner County Circuit Court. The case that will be argued here today is Robert Smith versus the State of Arkansas. It is about the murder of 72-year-old Elvira Fragenstein. Ms. Fragenstein went shopping in Conway, Arkansas on July 7, 2018. When she didn't return home that evening, her husband reported her missing. Surveillance video from the Conway Commons Shopping Center led police to believe that she had been abducted in her own SUV. A farmer found her decomposing body 4 days later in a field in Jefferson County near Pine Bluff. She had allegedly been beaten and strangled. Police developed two teenage suspects from Pine Bluff, 16-year-old Robert Smith and Smith's 18-year-old cousin, Takori Mackerel. Mr. Smith and Mr. Mackerel had allegedly traveled to Conway on the date in question with Smith's mother, and the two teenagers waited in the parking lot while Smith's mother played bingo. While waiting, they allegedly kidnapped Ms. Fragenstein, driving her in her SUV to Jefferson County and killing her and dumping her body. Both Smith and Mackerel were arrested and charged in Faulkner County Circuit Court with capital murder, kidnapping, aggravated robbery, and theft of property. But the two were tried separately. A jury found Smith guilty of all 4 charges, and he was sentenced to life in prison and without parole plus 90 years. Mackerel was also found guilty in a separate trial, and both Smith and Mackerel have filed separate appeals. The argument you hear today, however, concerns only Smith's trial and appeal. In the written arguments filed by Smith's attorney, Smith makes several claims of error concerning his trial. Number 1, that the prosecution failed to present sufficient evidence of his guilt. Number 2, the search warrant was not based on probable cause to believe evidence would be found in his home. Number 3, that certain text messages between Mackerel and Mackerel's girlfriend should not have been admitted into evidence. Number 4, that his life without parole sentence is illegal because he was a minor at the time of the crime. Number 5, that the prosecution made improper arguments to the jury that incorrectly suggested it was Smith's burden to prove his innocence. And number 6, that the court should not have allowed the prosecution to ask Smith questions about him getting into fights at school and about his alleged affiliation with a group known as Murder Gang. That Smith's attorney was improperly prevented from commenting to the jury about the fact that Mackerel was not called as a witness. And number 8, that a Murder Gang music video featuring Smith should not have been admitted into evidence during the sentencing. Based on these claims of error at trial, Smith asked that the Arkansas Supreme Court to dismiss the charges against him or, in an alternative, to grant him a new trial and or new sentencing hearing. In the state's written arguments filed by the Attorney General's office, the state agrees that Smith's life without parole sentence is illegal and argues that it should be changed to a life sentence that carries the possibility of parole after 30 years. The state disputes the rest of the Smith's claims and argues that the charges should not be dismissed and that Smith should not get a new trial or resentencing. The Supreme Court has reviewed the trial court proceedings and the written arguments of the parties prior to today's arguments, and the court will issue a written opinion explaining its decision in this case. Opinions are usually issued within a few weeks of oral argument.
All rise. Hear ye, hear ye, hear ye. The Arkansas Supreme Court is now in session. All persons having business before this honorable court, draw near, give attention, and you shall be heard. May God save these United States, state of Arkansas, and this honorable court. You may be seated.
Good morning. The rules will be relaxed at this time, and you may use cameras to take pictures until we start court. If you have a cell phone, please turn it off while court is in session. On behalf of your Arkansas Supreme Court, we want to thank Paragould and Greene County for inviting the court to hold oral argument here. We want to express our appreciation to Dr. J, Superintendent of Paragould School District, and Paragould High School Principal, Josh Shepard, for all their hard work in making this happen. Thank you also to Robert Thompson, Mayor Josh Agee, County Judge Rusty McMillan, the President of the Paragould Chamber of Commerce, Jake Bland, and CEO of the Chamber, Allison Heston. We also want to thank our deputy clerks, Bobby Jackson and Chuck Munson. Thank you to Pete Hollingsworth, the Supreme Court Chief of Police, and also Officer Robert Alpey of the Supreme Court Police. And to Chief of Police Todd Stovall, Sheriff Steve Franks, and all the members of the local law enforcement who are providing security while the court holds oral argument here in Paragould. Also, thank you to Vince O'Brien of the Administrative Office of the Courts for coordinating this event. Without the attorneys agreeing to argue this case in Paragould, we could not have held oral argument here. So the court wants to thank each of you for your willingness to argue the case here. We welcome the students of Paragould High School, as well as students of Crowley's Ridge Academy and Greene County Tech High School. Prior to 2000, the Supreme Court could not conduct court outside of Little Rock. With the passage of Amendment 80 to our state constitution, which is the judicial article which was passed in the year 2000, the court can now conduct court outside of Little Rock. And we have instituted a program which we entitled Appeals on Wheels. Since the passage of Amendment 80, the court has held oral arguments in numerous places throughout Arkansas, being Fayetteville, Bentonville, Fort Smith, Hope, Monticello, Blytheville, Texarkana, Helena, Harrison, Jonesboro, Pine Bluff, Russellville, Mountain Home, Fordyce, Batesville, Clinton, Heber Springs, and Arkadelphia. The court believes that it is very important to hold court in all parts of the state. It gives the people the opportunity to see their Supreme Court at work. Everyone can go to Little Rock to observe their Supreme Court. This is a very valuable educational tool that gives more people the opportunity to better understand how their Supreme Court works and the role of the Supreme Court as a co-equal third branch of government. Several years ago, we began live streaming the Supreme Court's oral arguments. Today is the first time that we are live streaming our Appeals on Wheels. And I want to thank Zach Kent, the network technician of Paragould School District, for making this possible. Now everyone anywhere with internet access can watch the court's oral argument. The oral arguments are archived, and you can watch the oral arguments at any time on the court's website. At this time, I would like to introduce the justices. I want to mention that Justice Karen Baker is not able to attend today, but she will be participating in deciding this case. Justice Baker is from Clinton. She served as a circuit judge in Faulkner, Hearsay, and Van Buren counties for 6 years. She served as a judge on the Court of Appeals for 10 years and has served 11 years as a justice on your Supreme Court. To my right is Justice Ronda Wood of Conway. Justice Wood practiced law in Conway. She served as a circuit judge for Faulkner, Hearsay, and Van Buren counties, served for 2 years on the Court of Appeals, and has served 7 years on your Supreme Court. And to her right is Justice Sean Womack of Mountain Home, now Springdale. Justice Womack practiced law in Mountain Home. He served as a state representative, a state senator, and as circuit judge for 8 years in Baxter, Boone, Marion, and Newton counties, and has served 5 years as a justice on your Supreme Court. To my left is Justice Courtney Hudson of Harrison, now Fayetteville. Justice Hudson practiced law in Fayetteville, served as a law clerk for the Court of Appeals, served for 2 years on the Court of Appeals, and has served for 11 years as a justice on your Supreme Court. To her left is Justice Robin Wynn of Fordyce. Justice Wynn practiced law in Fordyce, served as a deputy prosecuting attorney, state representative, district judge, and served for 4 years on the Court of Appeals. Justice Wynn has served for 7 years on your Supreme Court. And to his left is Justice Barbara Webb of Benton. Justice Webb practiced law in Little Rock, served as a prosecuting attorney, served as an administrative law judge with the Workers' Compensation Commission for 10 years, and chief administrative law judge for 2 years. Justice Webb has served 1 year on your Supreme Court. And I'm Dan Kemp from Mountain View. I practiced law in Mountain View and served for 9 years as municipal judge. I served for 30 years as a circuit judge in Independence, Cleveland, Izzard Stone, and Fulton counties, and I've been serving as Chief Justice for the past 5 years. Later this morning, after we finish oral argument, each of the justices will be speaking with the students in groups about our judicial system. The court will hand down a decision in this case possibly 3 to 4 weeks from now or shortly thereafter. And about 75% of our cases are handed down within 4 weeks, which is one of the fastest turnaround times of any Supreme Court in the United States. Again, I want to express my appreciation on behalf of the court for you inviting us to come here to Paragould, and we want to thank everyone for their hospitality. Mr. Bailiff, at this time, court rules will now be in effect. The court has some cases to hand down today, one of which is Civil 21-498, Bentonville School District versus Sidney from Benton County Circuit Court, reversed and remanded. Special Justice Howard W. Brill joins, Justice Womack and Special Justice Brill concur, Justice Webb dissents, Justice Wood not participating.
CV 21-485, Michael Henderson versus Dexter Payne, Director of Arkansas Department of Correction from Jefferson County Circuit Court, affirmed. Justices Wood and Webb concur in part and dissent in part.
CV 21-517, Leslie Rutledge, individually and as Attorney General of the State of Arkansas, versus Pratt's Cates Remmel Jr., Gail Stewart, Glenn Hooks, and others, from the Pulaski County Circuit Court, 16th Division, reversed and dismissed in part, and remanded. Motion to strike denied. Special Justice John Scott joins. Justice Womack concurs. Justice Wynn and Justice Baker concur in part and dissent in part. Justice Webb not participating.
CR-23-1071, Randall Thomas McCarty versus State of Arkansas from Clark County Circuit Court. Petitions pro se fourth petition to reinvest jurisdiction in the trial court to consider a petition for writ of arum coram nobis and a motion for appointment of counsel. Petition and motion denied. Justice Wood concurs.
Will the clerk please read the submissions?
There are two cases being submitted to the Supreme Court today for decisions. Both are appeals from the Circuit Court of Faulkner County. One of them is the case being argued orally today, case number CR-21-195, Robert Smith III versus the State of Arkansas. The other case being submitted is CR-21-27, Corey Mackerel versus the State of Arkansas. Additionally, there are 14 motions and petitions being submitted for the court's consideration. All of today's decisions and submissions are available on the Supreme Court's website.
Okay, thank you. This time the court will take up oral argument in case number CR-21-195, Smith versus State. And the court will recognize the appellate's counsel. Mr. Kaiser.
Good morning. May it please the court, the Chief Justice. My name is Michael Kaiser, and I stand here before you representing appellant Robert Smith III. Mr. Smith's parents and sister are here in the third row on the justice's right side, and we would like to extend a big thanks to Paragould High School and all of the students and faculty from around Northeast Arkansas for joining us for this very important argument today. On July 7th, 2018, Corey Mackerel caught a ride from Pine Bluff to Conway with his cousin, Robert Smith, and Robert's mother. Once they reached Conway and Robert's mother was no longer around, off playing bingo, Mackerel pulled out a PCP cigarette and smoked it. From there, things took an unfortunate turn. Mackerel, an adult, left his cousin Robert alone in his mother's car for several minutes before returning with the decedent, Miss Fragstein's car. And Robert entered Miss Fragstein's car as his older adult cousin demanded, saw Miss Fragstein dead or seriously injured within the car, and followed his older cousin's demands to drive back to their home in Pine Bluff. Robert was only 16 years old. 4 days later, Miss Fragstein's body was found dead in a farmer's field in Jefferson County. However, the state presented no proof as to what actually occurred between the time of Miss Fragstein's car leaving the Conway Commons on July 7th, 2018, and her body.
Counsel, I don't know if those facts are really the facts that are even presented in your brief. So, I mean, you're sort of laying out that he got in the car and saw Miss Fragstein being deceased, but I thought from your brief and even his testimony that he didn't necessarily even say that that was the case until he said he got in the car and started driving and then realized there might be someone in the back seat and wasn't even sure the status of that. So, I mean, are you changing his story?
I'm not, Justice Wood. I'm going off of Smith's uncontroverted testimony. His testimony was the only thing in the record that actually established what occurred between the time of Miss Fragstein's car leaving the Commons and her body being found several days later.
But he didn't necessarily say that he saw that she was deceased from the moment he got in the car at Conway Commons, correct?
No, I believe he noticed it a little later.
Okay, well,
And,
so we're not trying to suggest that today. And you're trying to suggest perhaps the older cousin is to blame. You keep emphasizing that, but this is an older cousin that I think in another case had some, mental difficulties, correct?
I'm not familiar with Mr. Mackerel's
Yeah.
case.
And what's the age difference between the two?
Mr. Mackerel was an 18-year-old, Mr. Smith was 16.
Right. So we're not talking about the difference of a 10, 15, 20-year-old adult male. We're talking about two really teenagers.
We're talking about two teenagers, one of whom is an adult under Arkansas
Right.
law, one of whom is a juvenile.
Okay.
Mr. Kaiser, this is a finer point, but Can you clarify for me the facts involving how the PT Cruiser got back to your client's mother at the bingo hall? What was the testimony there?
I apologize, Justice. It looks like the clock has reset. Are we just going to go with this? Okay. And I apologize, Justice. The question was about how
Well,
the PT
I'm following
Cruiser...
up on the factual situation that Justice Wood mentioned about when Mr. Smith got into the victim's car. How did the PT Cruiser get back to the bingo hall to Ms. Smith?
I believe the testimony from Robert Smith was that he drove his mother's car following Mr. Mackerel in Ms. Ragstein's car to the bingo hall, where Mr. Mackerel then demanded he get in Ms. Ragstein's car. He did, and they drive back to Pine Bluff.
Mr. Smith did not get into the victim's car in front of the target in the commons area?
No,
Okay, that happened at the bingo hall.
according to his uncontroverted testimony.
I just wanted to make sure that.
Mr. Kaiser, isn't it true that your client denied ever being in Conway when he was first interviewed?
Yes.
And at what point did he decide that that was not the truth?
I don't know, Your Honor. I'm just speaking on his uncontroverted testimony at trial.
And Mr. Kaiser, so I know that you, in your brief and then today, you keep saying that Mr. Smith's testimony is uncontroverted. But even though it's uncontroverted, that doesn't mean the jury necessarily has to believe it. And today, before us, when we're looking at, and you're saying there wasn't substantial evidence to convict him, but our standard is we look at it in the light most favorable to the state, not the light most favorable to his uncontroverted testimony. Isn't that correct?
Yes, Your Honor.
So we are looking at it as light most favorable to the state, so taking the evidence in the most favorable to what the prosecution presented. Was there enough evidence to convict him? And it doesn't matter whether he testified that, whatever he testified, whether he testified that he didn't see that she was deceased till much later, or whether his, he's 16 and his 18-year-old cousin said, hey, get in the car, and she's already deceased. It matters if the fact that there's videos of them scoping out store after store down Conway Commons, and then, immediately sort of her car driving erratically. There's video testimony of a tussle going on. He admits he gets in the car, he drives the car back to Pine Bluff. There's text message sort of pings, and we have the blood on the shoes, and she's stomped to death, and there's blood on his shoes. So if that's sufficient for a jury to find he kidnapped and participated in killing her, whether he's the primary or the accomplice, we take it light and most favorable. How is that not sufficient?
Respectfully, Your Honor, I believe the jury would have had to rely on speculation and conjecture in rejecting his uncontroverted testimony and deciding what occurred in that car without any actual evidence of such.
But they get to weigh the evidence, so it's for the jury to say whether they can find him completely incredible. It's not for us to weigh that.
Yes.
And the jury must have, to reach their decision.
I don't disagree with that. Clearly, they rejected the bulk or all of his testimony. However, even without it, the jury had to rely on speculation and conjecture to determine what occurred between the time of Fragstein's car leaving the Commons and her body being found. Even the presence of blood on my client's shoes is consistent with his testimony, and the photos of his shoes are inconsistent with someone having actually stomped someone to death with those shoes. They are more consistent with having walked in or having blood tracked on them as he testified.
Okay, but they also had evidence of your client participating in a video of the murder gang, in a video about stomping someone to death. So you add that together with her being stomped to death and blood on his shoes. You're saying that's still not sufficient?
Yes, Your Honor. It's our position that a music video made by a group of teenagers who are a rap group or a music group of sorts does not evince any criminal intent on the part of my client.
Mr. Kaiser, you've seen the video.
I have.
It doesn't appear that music video is comical, is lighthearted. Wouldn't you agree with that?
It appears to be a standard rap video, Your Honor. Rock music, rap music, there's a lot of discussion of death, killing.
Carrying armed weapons, some automatic weapons,
Um,
heavily armed.
There was no proof that there were actual weapons in that video as opposed to props. Again, it was a music video made by a bunch of teenagers.
Talking about being in a murder gang and killing people.
I did not see orange tips on the end of those weapons in the video.
Mr. Kaiser, your first point on appeal is that there was insufficient evidence for the convictions. And of course, the state argues to us that was not preserved for arguments to us. How do you respond to that?
I stand on the briefing.
What's that?
I stand on my briefing, sir.
Would you tell me, though, what you said in response to that?
That defense counsel Bloodman's argument preserved our issues. He said there was insufficient evidence to show that my client was a legal accomplice to the actions of Corey Mackerel. Your Honor.
Mr. Kaiser, I'd like for you to move to your point on appeal where you contend that the circuit court abused its discretion in allowing certain text messages. And for the benefits of the students, I would like for you to begin with Exhibit 50 and read that text message to put it in context with the listeners.
Yes, Your Honor. Your Honor, if I may retrieve an exhibit with all those
Certainly.
texts. And I apologize, Your Honor, I don't have the quote with me. This is the text regarding the purse.
This is Exhibit 50, and I will, if you don't have it in front of you, then I can read it to you. I just got the texts, and when we was up there, Cuz snatched the purse and it had $60 in it. He got 30, I got 30. I put 20 in the tank, and he bought an 20. And that is Exhibit 50.
Yes, thank you, Your Honor, for reading that
Please tell
quote.
me why you believe the circuit court abused its discretion in allowing that text message into evidence.
So first off, it's not a present sense impression. He's discussing something that's already occurred in the past. I know the state is going to try to say that this is him showing his excitement about having stolen $60. The text itself belies that assertion. Next, it's not co-conspirator non-hearsay pursuant to Rule 801 D2V. I would actually point the court towards the case of Kazivi State, which it issued just a few weeks ago. The statements here at issue, a co-defendant's text messages to his romantic, his spouse or partner, essentially bragging about his criminal exploits. In Kaziv, this court, all 7 members of this court, in the majority, the concurrence, and in the dissent, agreed that a co-defendant's braggadocio about exploits to a girlfriend did not qualify as appropriate co-conspirator non-hearsay. The same thing here. This case involves almost, I'm not going to say identical, but very similar bragging after the fact to a girlfriend by a co-defendant. It's a casual admission of culpability that in no way furthers the object of the conspiracy, so it's not in furtherance of any conspiracy, and there even wasn't proof that Mr. Mackerel's girlfriend was a conspirator in that conspiracy itself.
But wasn't there testimony that she actually received the purse?
There was.
And wasn't there an introduction into evidence of a selfie that she took in the victim's car?
I believe that's right, Your Honor.
So could those things, after the text message was sent, go to prove that the text message was, I guess, an appropriate exception to hearsay because it's proof of furtherance of a crime?
No, because it's our position that it's not in furtherance of the specific object of the conspiracy, the alleged abduction and killing of Miss Fragstein.
But there were other charges as well as forced theft of property.
Yes, Your Honor.
but it could have been in furtherance of.
It's our position that it was not in furtherance of that theft of property. This was merely a statement bragging about what he had already done. The fact that the young lady may have received a purse on the back end does not change what the communication was at the time it was made.
And then there was another object of property that was stolen, that was part of the theft, the automobile.
I was going to ask if the court's referring to the automobile. Yes, sir.
And it hadn't been discovered yet, or according to the testimony, hadn't been disposed of.
Your Honor, I actually do not, I cannot, I'll let the record speak for itself on that.
Well, counsel, the car, I don't think it was found until maybe July 11th, and this was sent, text was sent July 7th, and so, and at some point, if she's in the vehicle during that intermittent period, and then she's receiving part of the stolen property, so it's quite different than Kesey, because the girlfriend, there was no allegation that the girlfriend ever participated in the crime. She was just told on the front end, hey, I'm going to go to, unfortunately, Conway, and, you know, take these people out. Versus here, it is sort of, hey, I just got your text, and, you know, by the way, bringing you the purse, and then later you're going to get to go right around in the vehicle that, you know, we've stolen. So it's tied in much more, wouldn't you agree, than this girlfriend that had nothing to, you know, no sort of complicity in the crime or after the crime in Kesey?
No, Your Honor. The girlfriend in Kesey actually ran to Mexico with the killers after the alleged killing, so I think it compares quite favorably.
Well, and let me ask you this. So what the purpose of hearsay, why do we not let hearsay in? Wouldn't you agree it's because of the fear that it's not reliable?
Yes.
Right, that's the purpose of the hearsay exception, that we don't want testimony in that's unreliable. This, because of the untruthfulness, potential untruthfulness, that like you go tell Joe, or you said Joe said this, and then you come into court and say Joe said this, and we don't know that that's reliable, right? That's the purpose of hearsay, would you agree?
Reliability and the ability to cross-examine the
Right.
person under oath.
So with this, with the text, some of that potential unreliability is gone, because we know this isn't in fact what he wrote, the text says. Wouldn't you agree? I mean, it's his text from his cell phone, so there is a degree of reliability there. I mean, it's not a sort of an oral communication that we don't know if that in fact occurred. We have, you know, it in writing on his text.
Yes, Your Honor.
Okay. So some of the fear and danger of letting in the statement is relieved.
No, Your Honor. The analysis is about whether it is a valid present sense impression or whether all the elements of co-conspirator non-hearsay are met. They're simply not met in this case.
Well, and maybe you can address it more on your rebuttal, because I know
Yes.
we're into your rebuttal time.
And I see I've gone over. I appreciate the Justice's questions. I'll see you all very soon.
Court will recognize the state.
May it please the court, I'm Rachel Kemp, Senior Assistant Attorney General for the state in this appeal. This case is about an innocent 72-year-old woman whose routine Saturday afternoon shopping trip was cut short as she walked out of one of her favorite stores, TJ Maxx, and encountered appellant Robert Smith and his cousin, Corey Mackerel. Smith was 16, his cousin was 2 years older, he was 18. Smith and Mackerel abducted Elvia Fragstein in broad daylight from a busy shopping center in Conway, the Conway Commons Shopping Center. They stole her car. They inflicted upon her what the medical examiner testified as a severe and prolonged assault. They drove her car from Conway to Pine Bluff, where they dumped her body in a ditch. Smith was charged and convicted as an accomplice on an accomplice liability theory for capital felony murder, kidnapping, aggravated robbery, and theft of property. I would first like to address the sufficiency point and point out that this was an accomplice liability case, and so the evidence that was required was to show that Smith acted. He did not have to have direct participation in any of these offenses. He had only to have the intent to commit the offense and that he aided or attempted to aid his co-defendant, Mackerel, in the commission of the offenses, during the course of which one or both of them killed Mrs. Fragstein. And there was substantial evidence that he did that. He was not merely just present at the Conway Commons with his cousin, and his cousin demanded him to get in a plainly stolen car and drive it. The evidence that was presented included, and much of the evidence Smith admitted at trial. It's a 2 to 3 minute period where he claims that he had no idea what was going on. What the evidence showed was that Smith, Mackerel, and Smith's mother, Tasha, were all from Pine Bluff. They all drove together in Smith's mother's blue PT Cruiser on July 7th. Smith and Mackerel dropped off Smith's mother at a bingo hall. Smith and Mackerel together drove Smith's mother's PT Cruiser to the Conway Commons. They get there we have video surveillance footage that shows that the PT Cruiser parks in front of Target at 2:37 p.m. Minutes later, Smith and Mackerel both together get out of the cruiser. They both go into Target together. They both come out of Target together. There's photograph evidence showing the clothing that they're wearing as they walk out of Target. Smith is wearing a shirt with graphics on the front, but the back is solid white. He's wearing jeans and Nike tennis shoes. You can also see from the photograph that Smith is significantly shorter than Mackerel. And there's also testimony that Mackerel was about a foot taller than Smith.
And Counselor, in addition, as defense counsel pointed out, Mackerel's 2 years older. He's 18 years old, and some people view that as a significant difference between an 18 and a 16-year-old. And the question becomes, what did Smith know? What did this 16-year-old know when he is approaching the victim's car, and when he gets into the car, and with that limited or fulsome knowledge, the decisions he makes moving forward. So if you could kind of start addressing that, that's where I think it gets to be a little bit of a murkier area.
Right. Well, we see both of them. The behavior that they're engaged in, it looks like they're casing the parking lot and the storefronts. They're moving the vehicle around. They're looking in the store windows. It looks like they're looking for a victim. They both walk up to TJ Maxx right as Mrs. Fragstein is coming out, and she goes directly in their direction. And then we see her car, minutes later, we see her car drive off erratically and at high speed. And then we see it pull back behind Target. And in that video, we see the driver is wearing a white shirt. He's obviously shorter. He's a shorter person, just compared to where his head hits on the headrest in the car. The other head that you see in the car is taller. But then we have according to Smith's story, he gets in and he drives. He knows, he came there in his mom's car. This is not his mom's car. This is not Mackerel's car. It's a stolen car. He gets in it, he drives, but not only that, he admits that when he gets back there, he continues to help Mackerel move this car around Pine Bluff. They take it to Tashimia Bullard's house and leave it for a few days. And when Tashimia was concerned that it had been stolen, they both come back in Smith's mom's PT Cruiser to get the stolen car.
Counsel, let me ask you, because I think it's relevant, if we can go to the Conway Commons, and what I think you're saying and what you told the jury, because that the video behind sort of the TJ Maxx, you're saying that it's apparent the driver is in the white shirt, the shorter gentleman, which is Mr. Mackerel, correct, is what you sort of argued?
It's consistent with
Right.
his
What he was
appearance.
wearing in the videos as they're walking around minutes before Mr. Mackerel in a white T-shirt, Mr. Smith in a darker T-shirt. But what you're saying is there are two individuals at least that you see in that video and that we can see. And you're suggesting the second person you're seeing behind TJ Maxx when that car is not the victim in the car. So is that what you were suggesting to the jury, that that was actually Mr. Smith kind of controlling the victim?
Well,
Or
I think
perhaps
that-
killing the victim, struggling with the victim
I
behind
think
the
that
TJ Maxx?
the jury could reasonably conclude that it may have been Smith driving, because the shorter one is driving and the back of his shirt is solid white, and you're seeing the back of his sleeve, which is solid white. But it's not 100% clear.
Well, let me ask you this. So let's say that if what Mr. Smith alleges, let's say that his story is true. If Mr. Mackerel they went to Conway, they're at Conway Commons, they're doing drugs, they're walking around, and his story is true, that his 2-year-older cousin jumps out of the car, goes and basically kind of carjacks the victim's car, kills her in a matter of 2 minutes, comes over and gets him and says, basically, get in the car and let's drive to Pine Bluff. But he gets in the car, he sees her, doesn't know if she's alive or dead at that point, thinks perhaps she's dead, but he admittedly drives the car to Pine Bluff, the stolen vehicle, and then helps move it around Pine Bluff, takes part of the money. And then that's all we know, but then we know that afterwards that her body's disposed of and the car is burned. So even if we take his uncontroverted testimony, is there still enough for the jury to find sufficient evidence to convict him? That's really the question in front of us.
Yes, Your Honor, there is, because there's enough evidence to show that he intended to help Mackerel steal the car with the theft of the vehicle.
Ms. Kemp, let me ask you this, because I think the defense wants to make the case that when Robert Smith took the cruiser back to his mother at the bingo parlor, that's when Mackerel did these things to the victim. So what's the state's position about where Mackerel was and how the vehicle was actually returned back, the PT Cruiser, to Robert Smith's mother?
Well, I think that it's the same. I mean, you still have the evidence of them casing the place. There's evidence that they are working together to commit at least the theft. And so that Smith maybe drove the PT Cruiser back while Mackerel's murdering Mrs. Fragstein, he's still an accomplice to it. He's still liable for Mackerel's conduct.
Counsel, if he's charged under felony murder, so if you are stealing a vehicle with someone and that person unknowingly to you kills someone as an accomplice, under Arkansas law, are you equally liable and responsible?
Yes, I
Yeah,
believe.
so it doesn't matter, right? It doesn't matter if
Right.
he knew that she was killed or was going to be killed.
He did not have to be present at the crime scene to be.
Right, he didn't have to even be present at the murder, he didn't have to know the murder was gonna happen, anything, if there was sufficient for the jury to find that he was involved in stealing the car.
Yes.
Okay.
That's correct.
Let me ask about the text messages. Earlier question as to Exhibit 50.
Yes, sir.
And there's an argument by the defendant that, the appellant, that this was not in furtherance, this text was not in furtherance of the conspiracy. And what's the state's argument on that issue?
Well, I think that the evidence shows that the conspiracy is ongoing at that point, that this text is sent on the same day or like that evening of the abduction, and the body hasn't been discovered, the vehicle, they're still driving the vehicle around. And the actual statement, I believe Mr. Kaiser characterized it as Mackerel bragging about what he'd done, but it actually, it appears that he is telling Evans, his girlfriend, you know, kind of their plan of what they're gonna do with this what they're gonna do with these stolen things. He also tells her about the truck, and I believe she said, he said he put, you know, you can look at Exhibit 50, and he says he put gas in it, which, you know, intending to keep driving it, and that he tells her, now we have a ride, we can get around. So I think it goes to his intent to what he's going to do with this.
Well, when I read that text, I see a lot of past tense. I don't see, there's snatched, had, got, bought. I don't necessarily see that it is laying out a future plan, but more of a description of what has already happened.
Right, but he's I believe talking about it in the context of he's giving her this purse that they got from the vehicle that he's still driving and.
Well,
she's
if
driving.
any text that was sent during a time of an ongoing crime were allowed under this exception, then the exception would envelop the rule, and that can't be the case, just because they hadn't found the vehicle or connected the dots in terms of law enforcement. I feel like the state would need to have a more specific answer.
Well, I think that there's really just no prejudice from the statement, because that the purse was stolen, the theft is the vehicle, and there's plenty of evidence that Smith was tied to that, involved in that. And I believe that in Smith's brief, he argues that it was prejudicial because it was the only evidence showing that Smith received proceeds from his participation in this, but that's not an element of any of the offenses.
So would you contend that if this court found that the circuit court improperly admitted this text message, that it would be harmless error?
Yes, it would be. There's no prejudice from it, and there's overwhelming evidence that Smith acted as an accomplice in the offenses. I would like to just point out make one point with Smith's story. As the court noted, the jury was free to reject that testimony, and in this case, he admitted that he lied to the police before he was confronted with photograph evidence placing him there, and then said, okay, I was there, but this is what happened. But when you look at his story, you know, you see them before that, and they're clearly casing the place. And then you put that together with the descriptions and what they're wearing, the video from behind Target, and then also the medical examiner testimony that these injuries were sustained during a prolonged assault. And it's implausible to conclude that Mackerel, you know, jumped out of the car, did this in 1 minute, and then got back to Smith with the car.
Well, wasn't the testimony also that the bone that was broken here is so critical with blood supply to the head, that death is imminent?
Right, but the medical examiner couldn't say that that injury was the first injury, and there were multiple different forces, and I think that's why he concluded that this was a prolonged assault upon Mrs. Frogstein.
Counsel, can you address so we have two younger black males being charged, in the defendant in this case, the 16-year-old, being charged with murder, and of this older, you know, white female. The contention that either one, it shouldn't have been come in as a prior bad act, but whether it even is a prior bad act or overly prejudicial, that really the moment the video of Mr. Smith, the video of him being in the murder gang, so he has this murder gang music video, and it's played, and if you've seen it, I mean, there's the first thing that comes up when you see the music video is it pops up and it's a warning, right? That it's graphic and that there's violence involved and all of that. So first you see that warning, and then you come up, and it's uncomfortable. I'll just say it was uncomfortable for me. That really, I mean, was the trial essentially over the minute the jury saw that video? In a case like this, if that really was a separate music video that he filmed in bad taste, in bad judgment as a 16-year-old, the minute that the jury sees that video of kind of a group of, thug-looking, carrying weapons, singing, joking about murdering people, it's like game over for the trial. Was that...
Well,
can you see how that could be overly prejudicial to him getting a fair shot at this?
no, Your Honor, I don't. The video actually was admitted during sentencing after he had already been convicted on the capital felony murder and the other offenses. And you know,
Aren't they going to just max him out at that point?
Well, they didn't. The jury didn't max him out. So it's hard to see how it was prejudicial. And he had admitted during the guilt phase that he was a part of. Actually, I believe he testified about the stomping. I don't know if that even came up from the video in sentencing.
But it came in at guilt phase about him being part of this gang, really, or group that's kind of gang.
Right, it came in through his testimony in the guilt phase. But I don't think that was overly prejudicial. I mean, that was highly relevant.
I mean, there was an objection. It wasn't like he voluntarily testified. I mean, to say, hey, I'm a member of the murder gang when you're in trial for murder.
Right. Well, I believe what happened is before the trial, there was an agreement that the state was not going to make reference to his gang affiliation unless he opened the door. Well, he opened the door to his character during the guilt phase, and the state was able to question him about his involvement.
Well,
in
but
this
that's the
group.
issue in front of us, and that's what I'm asking you about, is did he properly open the door? But even if so, was the judge's ruling correct, or was it still overly prejudicial for that to come in? That's my question
it's
to
not.
you.
It's highly relevant. It's independently relevant to a main issue in the case, in the sense that it proves the material point that he says he is a member of this gang that stomps people. He's got blood on his shoes. She's got stomping injuries. He's wearing a gang-affiliated T-shirt at the time of the stomping. But it's not overly prejudicial because that there was sufficient evidence to convict him as an accomplice without him being directly involved in it.
And I guess, I mean, we don't want to convict people because of their affiliations. We want to convict them because there's evidence tying them to the crime.
And there was sufficient evidence tying him to helping Mackerel steal this car and all of the things that they did after to move it around and conceal the evidence.
Counsel, let me ask you on the issue on the sentencing order. How does the state propose that that be corrected where it shows life without parole?
It's the state's position that it looks like it's a clerical error that the circuit court could correct on its own. If the court believes that it's an illegal sentence, the court can order it corrected.
So remand for the circuit court to correct it?
Yes, Your Honor.
Just with specific directions?
I believe so. It appears that it's just the box that it's life without instead of the life box that's checked. The jury was instructed, well, actually, the jury did not sentence him on that one, but they were given parole eligibility instructions and given the instruction relevant to the capital murder committed by a minor. I'm saying that it appears clear that the parties believed that he was being sentenced to life with the possibility of parole, and that the sentencing order reflects something different.
Are there any additional questions? Thank you.
Thank you. If there are no further questions, the state would ask that the court affirm the convictions
And reverse and remand with specific instructions?
on the sentencing order.
Thank you.
Yes, Your Honor.
Okay, rebuttal for the appellant.
Thank you, Chief Justice. I'm going to start with the gang affiliation evidence issue. So first off, I just want to correct the facts from the state. The jury did max my client out. He received the maximum sentence on each of his possible convictions, and he received consecutive. So as the court knows, anytime we're dealing with gang affiliation evidence, the potential for prejudice is much greater than with any other kind of 404B type of evidence. And I'm actually going to point to the two cases the site stated in their 5-1J notice. Smallwood v. State, 326 ARC 813, a 1996 case. By claiming that he was not the type of person to threaten someone with a knife, Smallwood placed his propensity towards violence an issue. Thus, the trial court was allowed to ask about other violent acts or threats. And specifically, Smallwood admitted during his cross-examination to membership in a gang that was involved in selling drugs, stealing cars, and admitted that he had made a statement he would shoot anyone who threatened him. So just comparing that to the evidence here, Smith's testimony that he was not the type of person who committed a robbery, kidnapping, murder is not rebutted by a music video. I'd also just point out if the state, they won't have the chance, but Smallwood is a great vehicle for comparison, but it's also inapplicable because their attorney in that case failed to make the objections that we do here. Similarly, the case of King v. State, 338 ARC 591, a 1999 case from this court, is another great example of the limited circumstances in which gang affiliation evidence is admissible to rebut evidence actually introduced by the defendant. In that case, the appellant put someone on the stand to claim that the assault which the defendant was charged with was related to some other gang warfare that did not involve the defendant. The defendant himself put on the initial evidence about gang affiliation. The state was permitted to rebut that evidence with proof that the defendant himself was in a gang. We don't have that here. Justice Wood's comments are completely on point. The moment the murder gang was mentioned, the moment the video was shown, the moment the prosecutor continually referred to my client as MG Glow and kept saying that Ms. Ragsdine didn't have beef with MG Glow, was a dog whistle to the jury. And that's exactly what happened. And that's why my client has consecutive maxed sentences on each of these, even though he is the accomplice who, even by the state's charging decision, the lesser culpable party of the two.
Yeah, counsel, in Smallwood, it's correct that the defendant, the question was asked, the defendant answered, sometimes it's answered twice, and then the attorney objected. And that was part of the court's analysis, correct? Versus here, the attorney did object on the front end.
Yes.
Okay.
So it compares favorably, factually and legally.
But in light of the cause of death and a violent strike of some sort here, don't you think that that music video would go to show a violent sort of nature that could be brewing?
The court has an important decision to make in this case as it relates to a juvenile's affiliation with a music group. If the court is going to countenance the state treating a music video that already has a label on the front saying that it has this explicit content is evidence that the people in it actually committed what they're singing about, well, then yes, I guess it would be propensity evidence, but it's our position that it's a bunch of boys rapping, and that it doesn't rise to the level of actual gang evidence such as that in Smallwood, where he admitted to being in a gang that sold drugs and committed crimes.
Would an alternative be to have sentencing, have sentencing redone, bifurcating, or if the court thought that there was an issue with sentencing, would the entire trial have to be redone?
Well, we've given the court both options. We think it was error in both phases of the case. The admission of the video in the sentencing phase would warrant resentencing on its own, but admission of his alleged affiliation with murder gang as a gang during the guilt phase as 404B, or excuse me, as to fight fire with fire, I believe is how the court found it, would mandate a reversal and remand and retrial. So it's our position he deserves a completely new trial, that this gang affiliation evidence poisoned the well during the guilt phase as well as in the sentencing phase. Moving to the Fair Sentencing of Minors Act issue. Again, my client was 16 at the time he was sentenced to life without parole plus 90 years. The state agrees that this is a direct violation of Miller v. Alabama as well as Arkansas statutory law in following Miller, the Fair Sentencing of Minors Act of 2017. However, the state's concession on that issue is not the end of the analysis. The Fair Sentencing of Minors Act of 2017 is very clear that regardless of the original sentences imposed, that 30-year parole eligibility covers the entire case, not just the capital murder conviction. So we agree with the state that yes, the LWOP sentence itself is illegal, but we disagree as to what the relief should be. And here it should be remanded for a new sentencing order to show that his 30-year parole eligibility is across the board pursuant to 1693-621 A2A and A2B. I'd like to respond to the state's argument that the intent to steal Ms. Ragsdine's car is enough to convict my client of felony murder. That is just legally incorrect. The two underlying felonies charged here were kidnapping and robbery. While robbery has an element that is theft, theft alone is not robbery. So there was no proof, or it's our position there was no substantial proof that Smith actually promoted or facilitated Mackerel's violent crimes in committing a robbery and a kidnapping. So the state's contention that his involvement in the alleged theft of the car is sufficient to convict him of capital felony murder is just, it's legally wrong. Turning back to Corey Mackerel texts, the bulk of the state's case was the obvious evidence of Mackerel's guilt, Mackerel's text messages to Mackerel's girlfriend, and the prior bad acts evidence of my client. State's Exhibit 50, as the court pointed out, these are all in the past tense. The individuals had already used the money. It even appears the state conceded at the end of its argument that this was not co-conspirator non-hearsay, just instead pointing that it's harmless error that it was erroneously admitted. However, it was extremely prejudicial. It was the only evidence showing that Smith received anything from the alleged theft of Ms. Fragstein. So this was one of the single strongest pieces of evidence in this case, which was a circumstantial case, and thus makes its prejudicial impact that much more strong.
Counsel, let me ask you about the text message Exhibit 86,
Yes.
Exhibit 110. Now, did you in your brief mention anything on Exhibit 86, I believe, which is a blow-up of 110? Did you challenge that?
Your Honor, I challenge the substance of that text message. I believe I misnumbered the exhibit.
Okay, because I didn't see any challenge to it myself, so I was wondering whether there's any prejudice then.
I mean, perhaps in an ineffectiveness claim against me for failing to include it.
But you're claiming it was a clerical error, that you just misnumbered it?
Yes, and it's clear even the state acknowledges in a footnote in their brief that they understood which text messages were being challenged. We'd asked the court to
Right.
hold.
And reading the substance of it, we could connect the dots.
Yes.
Got it.
Mr. Kaiser, on the sentencing order, and I think I understood what you said. And of course, we know sentencing a juvenile with life without parole is illegal. But if we send that back for a sentence that is legal, are you saying that that should encompass the years that the jury gave him on aggravated and kidnapping and so forth, and encompass all of that in that one sentence?
Yes, Your Honor, based on the explicit language of 1693-621A2B, which refers to the parole eligibility applying regardless of the original sentences in the plural imposed.
Counsel, but 621A2A says offense singular, right?
Yes.
So where are you reading the plural?
In the next subsection, A2B,
Okay.
regardless of the original sentences imposed. The legislature, in their wisdom, would not have used the plural term there unless they meant that this covered the entire case. Rule of lenity, we think the statute speaks for itself, but if the court finds there is any ambiguity, the rule of lenity weighs in favor of my client. Any ambiguity has to be resolved in favor of a criminal defendant. Original sentences imposed, it's very clear that the FSMA covers the entire case, the entire aggregate sentence, not just the capital murder conviction.
Mr. Kaiser, what was your understanding of how this commitment order was done that caused the sentencing to be illegal?
Well, it shows that he has a sentence of life without parole, which as the
Well, I
court-
understand that, but how did that happen? Because I think the state acknowledges that at some point the parties agreed that a juvenile could only be sentenced to, to life and 30 years, eligibility for parole.
Your Honor, I don't know how that happened, and that's why I believe it needs to be remanded for the trial court to resolve.
State indicates it was just a clerical error, possibly. Do you
Well,
disagree?
if so, then this court is empowered to correct it in this appeal. And I would ask this court to correct it, if the court were to affirm to at least modify the sentencing order. If the court reverses, it would be moot.
Thank you.
Thank you all for your time. We would ask the court, based on our arguments and our appellant's brief and reply brief, to reverse and dismiss my client's convictions, or alternatively, to reverse and remand his case for retrial without the same evidentiary errors. We appreciate your time and your time as well. Thank you very much.
That concludes our oral argument in this case, and court will be in recess to visit with the students following a 10-minute recess.